My name is Keith Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're going to continue our video series designed to educate and inform the public. So please subscribe to our channel. Today we want to inform you about a very interesting issue relating to getting a summons and complaint. You know, when a divorce action is started, that means someone filed an action with the court, went to the court clerk, paid the fee, court clerk stamped it, did whatever they did, randomly assigned it to a family court judge in that circuit, and that judge issued a summons. Summons is an order to take action, and that directs you to do something within a certain amount of days. And that summons is attached to that complaint. It's sent back usually to the law firm that drafted the divorce, and then they serve it upon you. And now you've got a summons. You've got a complaint. What are you supposed to do with it? What is your legal responsibility? If you read the summons in very ominous language, says you are being sued, you have to take action within a certain amount of time, or you risk default. You know, some language that makes you wonder, gee, this is a legal proceeding. This is important. I better do something about it. The reason why it gives you a certain amount of days and tells you have to react within a certain amount of time is because you would not believe how many people get it and go, legal papers. Well, I don't really want to deal with this, so I'm just going to put it in the drawer and be done with it. And then they have all sorts of problems later on because they've blown the time elements, etc., because it's time sensitive. So in order to avoid people from taking an approach that actually jeopardizes their rights, the court set up this form and put language in there in such a way to motivate people to understand the gravity of this. And why? To protect themselves. The court is really trying to protect people from taking it and putting it in some file somewhere and forgetting about it. Like medical things, legal things don't typically get better if neglected, okay? They tend to get worse and the situation gets more dramatic. So therefore, if you get a summons, read it. Then read the complaint that's attached to it. There should usually be a complaint that says you're soon-to-be ex versus you. It tells where you live, when you were married, did you have children. It says that there's been a breakdown of the marriage. It says that there's property to be divided. If there's children, it'll name the children. It'll probably say what their dates of birth are. There's certain things. And it'll ultimately say there are issues that have to be resolved by the court. Custody, parenting time, child support, property issues, this and that. And then it's going to have a wherefore paragraph. And that wherefore paragraph is the paragraph where they ask for relief. And they may ask for custody of the kids. They may ask for a fair division of property or any other relief that the court deems appropriate. It may also say that they want you to pay the attorney fees on the other side, plus interest and cost, and all sorts of things that would make one wonder, oh my God, what's going on here? When you get that, it's not the time to sit on your hands and put it in a file somewhere, but rather it's the time, now that you've read it, now that you see what it is, you've got to reach out to your lawyer. He or she's going to say, send those papers to me right off the bat, and they're going to know what to do. And you know what they're going to do? They're going to contact the attorney who filed it. They're going to draft an answer in accordance with the court rules, an answer that satisfies the court rules so that you're not in default by not answering on time. They're going to serve the other side. They're going to file it with the court. They may file a counterclaim on your behalf, and so the case will begin. But you have to understand one thing. Serving the case begins it. Answering it puts it in a better posture. Both parties are in. Both parties are asserting their position. If you ignore it, if you don't take it seriously, their side is running to the finish line. You're stopped. You're not even with them. You're all the way back here. And once you wake up and decide, ooh, I better take care of this. It's 4 months later, but I'm going to send it to a lawyer. That lawyer, he's not going to have the same position, the same ability, the same maneuverability that he might have had he started the race at the same time as the other side. Now the other side has a huge head start. He's got to play catch up. And then he's got to ask the court to set that default aside. Technically speaking, if there's a default, he's not even allowed to file pleadings. He's got to ask the court first to remove it, and then he can catch up. Now, the courts tend to be forgiving to some degree in these kind of things, but it's very individually formatted for the judge. Some judges will easily set aside a default, some won't. So you really have to take that very seriously, and those are the things that you do when you receive a summons. Now, if you have any questions about that, reach out, and we'll be glad to help you out.